Okay, everyone, I want to thank you so much for joining us today for this webinar with respect to AB 1360. I'm Angela Turner. I'm a staff attorney with Public Counsel, and I'll be joined by a few of my colleagues, which I'll introduce momentarily. So, next slide, please. So we're just going to run really quickly through the agenda and then do a few introductions to start. So today we'll run through the agenda. We will let you get to know us a little bit. It's a broad range of us on the call today with you. We will discuss due process. We'll talk a little bit about ensuring fair admissions, and then we'll talk about what you can do in your communities. So your presenters today are myself, Angela Turner. I'm a staff attorney at Public Counsel. We also have Angelica Hunko with Public Advocates, my colleague Ashley Washington with Public Counsel, Oscar Lopez with the East Bay Community Law Center, and Victor Leung with ACLU Foundation of Southern California. So now we're going to do a quick poll so we can know a little bit about you and who's joining us today on the call. So you should see that poll, and I would recommend if you can just click one of the boxes, whatever applies to you. And I can see that lots of folks are currently clicking those boxes, so thank you so much. So we have just a few folks who haven't voted. We'll give it another moment if you've hesitated a bit. Great, I think we can actually go ahead and close that poll. And it looks like a lot of other, a few charter school authorizers, some school staff, and maybe an operator or two, and some community members. If you said other, could you just type in the chat box what your role is? So it looks like we have a few lawyers, some partners, and a few community organizers. This is great. Great. It looks like we have a really diverse group of folks on the call today, and we want to thank you all for joining us today. So can we go to the next slide? So today we're going to talk a little bit about what AB 1360 is and what is AB 1360. AB 1360 is a new law basically to clarify the obligations of charter schools. It basically clarifies that charter schools have to provide due process protections for students before their suspension, expulsion, or any involuntary removal from the school, and that charter schools must admit all students not by not using any admission preferences that might exclude students from historically underserved backgrounds. So we're going to go into this next section and just talk a little bit about due process for students and their families, and I want to introduce my colleagues who will be speaking to that point. Ashley Washington will be speaking for part of the time, Oscar Lopez from the East Bay Community Law Center, and myself will be chiming in a little bit about due process today. So as you can see, in March 2016, the UCLA Civil Rights Project released a report entitled Charter Schools, Civil Rights, and School Discipline. And that report really highlighted some of the disparities in school discipline with a specific emphasis on charter schools. It analyzed national data for the 2011-2012 year. One of the things that was found by the study, as you can see, there were numerous things that were found by the study, but one of the things that was highlighted was that nationally, charter school suspension rate was a little higher than non-charter school suspension rate. The 20 highest suspending charter schools in that school year all suspended more than about 2/3 of their student body at least once that school year. And most of those schools, all but 6, had greater than 52% Black enrollment. However, lower suspending charter schools overall were found to be more numerous nationwide than high suspending charter schools. So like non-charter schools, there are many charter schools that reserve suspension as a measure of last resort, and many charter schools that are working to address disparities in discipline. It's really important to note when discussing this issue that studies consistently show that differences in discipline rates for students of color and white students are not due to any differences in rates of misbehavior. In fact, a 2015 Stanford University study on teachers' implicit bias found that when teachers were reviewing a description of an unknown student's misbehavior, and they were told that that behavior was a second occurrence and that they were likely to recommend harsher discipline if the repeated offense was associated with the name of a Black student than when it was associated with the name of a white student, despite the fact that the written descriptions of the incident itself were exactly identical with the exception of the name of the student. And this lends itself to the conclusion that the disparities that we see are really related to implicit bias as a contributing factor in discipline disparities. Next slide. So what are some of the consequences of exclusionary discipline? High rates of out-of-school suspension equal lower achievement rates even after you control for other factors such as race or poverty. They're also linked with worse school climate ratings, and they're also linked with some adverse consequences for suspended or expelled students. As you can see on the slides, suspended or expelled students are 6 times more likely to repeat a grade, 5 times more likely to drop out of school, and 3 times more likely to have contact with the juvenile justice system. In addition, it's important to note that the earlier a student is suspended in their academic career, the more acute the impact on the student. Numerous experts in pediatric health have weighed in to point to research that argues that exclusion and other punitive approaches to discipline are often counterproductive and should be really measures of last resort. So I want to pass it along to my colleague, Ashley Washington, to talk to us a little bit about what this looks like on the ground.
Thank you, Angela. So just want to give y'all 2 quick examples to kind of add color and shape to what Angela just mentioned. So 2 examples from what we've seen here in LA are a parent who had their child enrolled in a charter school. The child was having both relationship challenges with teacher and a few behavioral challenges, and the way that the teacher handled the behavioral challenges really left the child feeling unsafe, left mom feeling like he was unsafe. And so mom kept the child at home for a couple days to try to create a plan with the school. You know, is there a safety plan I can do with my child so that they can we can address the behavior, but they don't feel unsafe. The school would not respond. And then once the parent said, you know, I'm talking to advocates to see what my rights are, school sends parent a letter that says your child has been disenrolled because they have missed X amount of days. You know, even though the school knew why mom was holding back, so they just got that letter that said your child has been disenrolled. No safety plan, no any other connection. My second example is of a student who was being expelled from school. So another charter school told the child and parents that he was just being expelled. Like, that's the only information they got. Your child is being expelled. Come to this meeting to decide which school you want to go to. So, of course, we advise the parents on their due process rights. We advise on the necessity of a hearing, on their obligation to give a hearing, and kind of the questions to ask at this meeting they go to. They go to the meeting with the school, and the school says, no, there will be no hearing. Here are your 3 options for schools. Pick one. Your child cannot return here. So in both of those examples, I just want to highlight that for the one, both of them were exclusionary discipline, right? For the one, there was notice but no hearing. For the expulsion example, there was notice but no hearing. And then for the first example, the disenrollment, there was no notice or no hearing. So so these students had to face the consequences that Angela just went over. All of the consequences of exclusionary discipline, they had to face them, but without any kind of protection for their due process rights. And I'm going to hand it back to Angela.
Wonderful. I'm actually going to pass this one over to Oscar Lopez, if he's on the call, so he can share a little bit more about the specifics of due process and then start walking us through the changes under 1360. Oscar? Okay, well, I'm going to go ahead and just share a little bit about due process. I think Oscar's perhaps on mute if we can remedy that situation, but I'm just going to share a little bit very quickly about due process. Generally, due process safeguards individual rights, as you can see from the slide. And as Ashley sort of highlighted a bit earlier, one of the primary facets of due process is notice, an opportunity to be heard, and then an impartial hearing. So Oscar, you should be able to weigh in now. Can you share your thoughts?
Hey, can everyone hear me?
Yes, we can hear you.
Oh, okay, great. Thank you so much. So hi, everyone. My name is Oscar Lopez. I'm an attorney with the East Bay Community Law Center. I just wanted to give you a quick summary of what it means to have due process in suspension and expulsion proceedings. So generally, due process means that there are certain protections that individuals are afforded before they can be removed from schools. Generally, the basics include notice, an opportunity to be heard, and an impartial hearing. And because of AB 1360, many of these due process protections are now clearly applied to charter schools as well. So, next slide. So, AB 1360 essentially said that any federal and state constitutional requirements also apply to students who attend charter schools. And you may be asking yourself, what exactly does that mean? So my goal here is to give you a bit more guidance on the minimal due process that's required, its origins, and currently existing practice in California as it comes to due process. Next slide. So there are essentially two different categories of due process rights. There are suspensions of less than 10 days and suspensions of 10 days or more, which can include expulsions. The first one that we're going to discuss is suspensions of less than 10 days. Next slide. Thanks. Next slide. So first, it's important to note that AB 1360 codified pre-existing federal and state constitutional requirements. Essentially, this means that these requirements were already granted to students, but AB 1360 made it clear exactly what those requirements are. So the origins of these requirements date back to a case called Goss versus Lopez. Goss versus Lopez was a case heard by the Supreme Court of the United States in 1975. The case involved a group of students who were suspended for 10 days from several public schools in Columbus, Ohio, for participating in student demonstrations. All of the students were suspended by their principal without a hearing, so they filed a civil rights lawsuit against the Columbus Board of Education. The Supreme Court concluded that suspending students could seriously damage the students' standing with their fellow pupils and their teachers, as well as interfere with later opportunities for higher education and employment. As a result, the Supreme Court stated that suspending a student for up to 10 days without a hearing is a violation of the student's federal due process rights. The court went on to explain some minimum due process requirements for students in suspension proceedings of 10 days or less, which include providing oral or written notice of the charges, and if the student denies those charges, providing an explanation of the evidence that supports those charges, and providing an opportunity for the people to present their side of the story. In the case that I mentioned, Goss versus Lopez, failure to comply with these minimum requirements resulted in expungement of the suspensions from the student records of those 10 students that were suspended. These are essentially the same due process rights that have now been incorporated through AB 1360. Next slide. However, as I mentioned, these are only minimal requirements. The California Education Code actually goes further, but there is still an open question which of these rights, if any, go beyond what is required by federal law. I will not attempt to address that ambiguity, but because of that, I do encourage all charter schools to adopt these protections in full. Some of these additional protections include limiting the grounds for suspension, limiting suspensions to situations when other means of correction fail to bring about proper conduct. And that means that schools should attempt to use parent conferences, referrals to counselors or psychologists, study teams, psychoeducational evaluations, restorative justice, and community service, for example. The additional protections also include restricting the total number of days of suspension. So, for example, a student cannot be suspended for more than 5 days for any particular action, and over the course of a school year, they cannot be suspended for more than 20 total school days. The California Education Code also establishes a right to a hearing within 2 days in what are called emergency suspensions. And these are essentially suspensions when it is deemed that maintaining the student's presence on school would create a continuing danger, in which case the student can be suspended without a suspension prior to being removed, but the school is required to have a hearing soon thereafter. In addition, some of the school principal is also supposed to write a decision notifying parents about the suspension and also providing a right to appeal of that suspension. Next slide. So that brings me to the second category of suspensions, and that's suspensions of 10 days or more, and also expulsion. The due process rights afforded to students for these kinds of removals from school originate from a case called Dixon versus Alabama State Board of Education. Essentially, the Supreme Court has never explicitly defined the minimal due process requirements for students recommended for expulsion, but in the case that I mentioned earlier, Goss versus Lopez, it did imply that the minimum requirements for quote-unquote tax-supported educational institutions could be found in a case from 1961 named Dixon versus Alabama State Board of Education. The case involved a group of Black students who attended an HBCU. The students went to a lunchroom in Montgomery, Alabama, in a Montgomery, Alabama courthouse, and were refused service. Police authorities were called on them. As a result, several hundred students organized mass demonstrations, but after receiving a call from the Alabama governor, the president of the HBCU told the students to quote-unquote behave themselves and return to their classes. The students were subsequently expelled without any notice, hearing, or appeal, so they filed a due process complaint alleging that their 14th Amendment rights were violated. After considering the facts, the Fifth Circuit Court of Appeals concluded that the due process clause requires, at minimum, notice and opportunity for a hearing before a student can be expelled for misconduct. Since this case, several other decisions have been made that further define the minimal notice and hearing requirements, including a 1977 case called Gonzalez versus McEwen, which originated from the Oxnard Union High School District in California. Next slide. In Gonzalez, again, it was a case of students in 1970. The students were expelled for their involvement in the demonstrations and filed a due process complaint against the district. The court stated that notice must include at minimum a statement of the specific charges against the students and a statement of the basic rights to be afforded students. Again, these are essentially the same, this is essentially the same language that has been incorporated into AB 1360. Next slide. The case of Gonzalez versus McEwen also discussed minimal hearing requirements, including the right to be represented by counsel, to present testimony, evidence, and witnesses, to confront and cross-examine adverse witnesses, and to have a fair and impartial fact finder. Next slide. And again, I'll note that these are only minimal requirements. The Education Code actually provides even more specific requirements. And given the seriousness of an expulsion, I would especially encourage charter schools to adopt the Education Code for procedures in full. Doing so can provide clarity for students and staff about proper procedures to follow. For example, You may have noticed that AB 1360 requires timely written notice and that a hearing be held within a reasonable number of days. These are somewhat vague terms, but in the Education Code, it is clear that timely written notice must be given at least 10 days before a hearing. The Education Code also establishes that a hearing must occur within 30 days of the alleged misconduct. In addition, the Education Code says that written notice must indicate the date and place of the hearing and the right to inspect and obtain copies of all documents to be used at the hearing. It defines a standard of proof as substantial evidence that the student actually committed the alleged acts, that other means of correction have repeatedly failed, or that the pupil presents a continuing danger to the safety of other pupils, and that this determination cannot be based solely on hearsay. And most importantly, the Education Code also says that if a board decides to expel a student, the student must be given the notice of the right to appeal the decision. I think it is important to consider that many of these laws were an attempt by courts to protect students who were standing up for racial justice and civil rights. And given this legacy, I would encourage charter schools to adopt these protections. And with that, I'll turn it over to Angelica to discuss involuntary removals of students.
Oh, no, that's going to be me, Oscar. This is Ashley.
Thanks, Ashley.
So thanks, Oscar, for going over both what AB 1360 spells out for charter schools and then what the Education Code goes a step further, and we hope that folks consider adopting that. And so the last one I want to go over is involuntary removals. And so students are owed due process for involuntary removals, and so those include anything that has to do with the student's transfer rights. So the first example I gave earlier, which was a disenrollment, it also includes dismissals, transfers, or terminations. It does not include suspensions. So just any interaction from the school that is involuntary, in which the student would have to leave the school and not be able to return. So there is a notice requirement. Parents must give, the parent or guardian must receive written notice no less than 5 days before the effective date of the removal. The written notice should be in a native language, and then it should.
Hi, this is Angelica Honko. I'm a senior staff attorney with Public Advocates. Thank you all for joining us. This is an important new law, but the only way that it will really have impact in the field is if folks are learning about it and kind of spreading the word and what it means. So I appreciate all the good questions, people being very engaged. I'm going to share this section around kind of the equal access provisions or fair admissions provisions of AB 1360 with my co-presenter Victor Leung from the ACLU of Southern California. And also for those who have been asking, there are resources that are going to be available along with the slides. We also have a handout that summarizes many of the provisions we'll be going over. So the general rule when it comes to charter school admissions that many may be familiar with is that a charter school shall admit all students who wish to attend the charter school. So that sounds pretty black and white. If there are not enough spaces, the charter school may hold a lottery. That kind of language begs the question, then why are the AB 1360 admissions preferences language and equal access provisions necessary at all? Well, Public Advocates has kind of been working in this area for several years. Next slide, please. And we have been, we and also our other colleagues on this call have been hearing, various, we've been getting various intakes from parents and students related to some charter schools. Here are just some of the examples. A mother who contacted us to say that when on the first day of school, the school made her go out and told her that they would not re-enroll her son unless she went out to Costco to buy 3 boxes of paper because she had not met her volunteer hours requirement in the prior year. So what did she do? She went out and she bought 3 boxes of paper, came back, and they enrolled her son. Another observation a parent made was that although people of color make up 90% of their local population, the school that their child was at only was enrolling 10% people of color. We've also heard from a student who said in the first semester of 8th grade, I was kicked out for failing to maintain a 2.0 GPA. So these are just some examples, real life examples that we have come across, and maybe others on the call have seen other examples. So this became clear that some charter schools were not clear about their obligations and what it really means to admit all students. So like I said, there has been some history of advocacy around this issue. In November of 2014, Public Advocates released a report that specifically was looking at the practice of having volunteer hours requirements as a condition of a child being able to attend a charter school. We found of the 300 schools policies that we reviewed, 1 out of 3 had some kind of parent volunteer hours requirement. And now, at first blush, some might ask, well, what's the big deal? Of course, schools can and should encourage parents to play an active role in children's education. But not all children are fortunate enough to have caregivers who can afford to take time off of work, who have access to childcare or transportation that would allow them to do so. So while schools should encourage parental participation, public schools, including charter schools, must not force parents to do work at the school or to pay fees in lieu of doing work, pay some kind of amount of money as a condition of their child's enrollment or participation in educational activities. After we issued this report, the California Charter Schools Association agreed, as did the California Department of Education, which put out a guidance in January of 2015 that explicitly prohibited requiring parent volunteer hours as an illegal fee that public schools may not charge. That guidance was recently updated in January of 2017 and is one that all school operators should become familiar with. And then in August of 2016, Public Advocates and the ACLU teamed up to kind of revisit and see where schools were at, with respect both to the volunteer hours policy, but also looking at other potentially exclusionary policies. In our unequal access report revealed over 200 California charter schools that had some type of policy that had the potential to exclude. Many of these were pre-enrollment requirements that included submitting certain immigration-related documents, only enrolling students who meet a certain level of English proficiency, enrolling students who satisfy a minimum academic performance. Again, we still saw the parent volunteer requirements, or requiring students or parents to submit burdensome essays or conduct interviews before enrollment. We saw that these variety of admissions policies can be exclusionary by barring or by creating barriers to being able to access the school. So following up on that report, we really saw progress. Many schools reached out to us to seek support in changing their policies or practices, or bringing their policies into line with what they said their practices were. But as recently as last week, it was brought to my attention, again, a 30-hour parent volunteer requirement at a charter school. And I also just checked another charter school that I'm aware of that still has a 40-hour parent volunteer requirement if you have two kids in the school. So we still have work to do here, I think, in educating the field and really making sure that charter schools are providing equal access. So in September 2017, AB 1360, which was authored by Assemblymember Rob Bonta here in the Bay Area, was signed into law, and it was co-sponsored by many on this call, including Alliance Boys and Men of Color, Public Advocates, Public Counsel, ACLU, the California Teachers Association, and the California Charter Schools Association. So I'm going to pass it over to Victor to talk about the specific provisions in the law.
Good afternoon, everybody. This is Victor Leung, Deputy Litigation Director at the ACLU of Southern California. So going off of what Angelica said, I just want to provide a little bit more detail on what specific admission preferences charter schools can enact in light of AB 1360 and the General Charter Schools Act. And so charter schools can enact certain admission preferences but only under very limited circumstances. Three major rules are: one, any sort of preference or any sort of policy regarding admissions needs to be approved by the chartering authority at a public hearing. So schools need to be transparent, need to be very upfront with any potential policies, and then the public will have an opportunity to provide input or challenge them if there are any issues with them. Second, policies, of course, must be in compliance with both federal and state laws, including the constitutions. And this includes discrimination or civil rights laws. So as you know, other government agencies cannot, charter schools cannot discriminate on the basis of race, gender, disability, sexual orientation, or any of the other protected categories. And then finally, as Angelica mentioned, charter schools are public schools, so they are bound by the California Constitution's free school guarantee, and they cannot charge parents or students money for access or require that they volunteer or work as a condition for allowing the student to come to the school. Now, with that said, a charter school may encourage parental involvement, and I think we all on this panel agree that it is very critical for families to remain engaged in their children's educations. But this has to be an encouragement rather than a mandatory requirement. Next slide, please. And so specifically, when we're talking about admissions requirements, so we're talking about the policies that govern who can or cannot attend the school. What AB 1360 does is make clear that if any sort of policy cannot limit or discourage enrollment access to any of these groups. So students with disabilities, academically low achieving students, English learners, neglected or delinquent students, homeless youth, low income youth, foster youth, or as I said earlier, students in protected categories, in particular race, nationality, ethnicity, immigration status, or sexual orientation. Next slide, please. And so let me provide some examples of what impermissible admissions policies would look like. And so, as we saw in our report, just on the website or in the materials stating that students with under 2.5 GPAs could not apply, or students with under 2.5 GPAs would be asked to leave the school, or to have certain minimum test scores to be able to attend the school. We also saw minimum English proficiency requirements. So for both students and families, it's actually quite shocking that several schools in the state required parents to be proficient in English for their student to attend the school. All of this is impermissible, both under AB 1360 and under the old rules as well. We talked about mandatory parent volunteer requirements already. Essays or interviews as part of the application process. Now, this is a trickier issue, but really what is impermissible is to require students to submit essays or interviews and then to use those as a way to judge students and only admitting students who perform well on them to the school. That is absolutely impermissible. It's also generally impermissible to have very onerous essay or interview requirements, because that may discourage certain types of students or certain families from enrolling. For example, it might discourage a homeless youth who would be intimidated by a very long application or a very long essay process from applying, or may discourage families who are non-English native speakers from applying if they couldn't understand the materials. I'm getting to the next point, not providing translating materials. Charter schools should provide translating materials, particularly if they serve communities, large communities of non-native English speakers. And then finally, let me just provide a little more background on this last one, immigration status or documentation. Obviously, this is, we're a little more careful about this one in light of Trump administration's heightened focus on immigration enforcement. And so, just to be clear, the Supreme Court in a case called v. Doe, it's long held that undocumented students and immigrant students do have a right to public education. So no charter public school can claim to present citizenship information, but it goes beyond that because it's a best practice for charter schools and for traditional public schools to not ask students or families for any such information at all. And examples would be passports, social security cards, US birth certificates, or other immigration-related documents. And the reasoning behind that is because immigration authorities may one day subpoena citizenship information from schools, and it really would be best if schools did not collect that information in the first place, so there would be no information to provide the federal government. I just want to add one more note, which talks about two different laws, AB 699 and SB 54. These are two laws the California legislature passed last year and that Governor Brown signed into law, which prohibit government agencies, such as school districts, from affirmatively sharing this kind of immigration information with immigration authorities. So you should understand that there are multiple levels of protection in place for students who may not have documented status or who may be recent immigrants. Okay, next slide, please. And so one very important thing to note, and this is where I'll close out, is even if a charter school authorizer or operator has great intentions in creating policies, the school and the authorizer has to be extremely careful that these policies do not have any negative impacts or otherwise exclude access for certain students. And so using the essays or interviews requirements as an example, we on this panel absolutely understand that it's really important to gather information from students to ensure that you provide them with the proper supports. We understand it is imperative to encourage family engagement with your school, and then also for you to let families know about your school and your communities and what you can provide to them. And so it is sometimes necessary for charter school operators to collect this kind of information, but the best practice is to guarantee students and families a spot first on a random basis, so it has equal access to all families. And then after that, when there's no danger of excluding access, to then ask students for, if you want to have an informational interview to kind of meet the families and kind of answer questions, or if you want to ask students to submit some additional materials so you can figure out how best to support it, that would be the best time to do so. So there is no risk that certain students might be excluded at the outset. And finally, we would encourage everybody to observe very carefully and on an ongoing basis the demographics of the charter schools that you're related to, and to make sure that the demographics of the school align with those of the communities that the schools serve. And as Angelica mentioned earlier, if the school is not serving as many students of color as in the community, or as many low-income students, or as many homeless youth as are in the community, then it's really incumbent upon the school and the authorizer to do some self-reflection to figure out what barriers that exist that are creating these disparities, and then do everything they can to eliminate them. Okay, so we're going to go through what various stakeholders can do. Charter school authorizers. So we did see that there were a few on the call. First, obviously, thank you for attending this webinar. Please do review some of the materials that we're going to link to at the end of the presentation. And we hope that you familiarize yourself with both the Charter School Act and the rules in AB 1360, so you have a very clear understanding of what the requirements are for the schools that you authorize and oversee. And then second, obviously ensure that any charter schools seek authorization comply with these rules, and if they don't, then immediately call them out on it and make sure that you don't authorize the school unless all of their everything in their charter and everything in their manuals and public-facing documents and policies comply with these rules. We encourage you to, when we were writing the report and reviewing data, we looked at schools' charters, their handbooks, the forms, the admission forms, the websites, and all of those other documents. And it was actually quite shocking to see how many violations were in there. So really, we encourage you to, review all that material, both at the outset and on an ongoing basis to make sure that they comply with the law. And then as we mentioned earlier, you should definitely analyze whether charter schools' demographics align with those in their neighborhoods. And if they don't, then you need to figure out why and then eliminate all of those barriers to entry. Potentially it's confusing language on the website, or it's a requirement that discourages certain groups that you didn't expect. We hope that really, I think the promise of charter schools, hopefully we can agree on, is to expand high quality educational opportunities to all students. And so we need to make sure that all charter schools remain open to every single student, particularly those who need it most here in California. And then finally, spread the we're going to put a copy of this webinar, like the video, up that website that we're about to link to. We're going to have this PowerPoint up. We're going to have a 2-pager that's really easily digestible. So we hope that you spread the word to other stakeholders that you know, other authorizers, the operators that you oversee, to make sure that they all understand the law and can help improve this good work. Next slide, please.
So this is Angelica here from Public Advocate. So for charter school operators, again, familiarizing yourself with the requirements of the Charter School Act and AB 1360. Taking a close look at the material that you're putting out publicly, your website, your handbooks, the application process, to consider whether they are both in compliance on the due process front and make clear to families and students what their rights are under the law, as well as whether they are creating any potential barriers in terms of students, especially from these the student groups named in the law, are in barriers to them being able to access your school. And so that means really erring towards inclusive and welcoming language, translating materials for members of your community, and as seeking to provide due process protections that may exceed what AB 1360 requires. So AB 1360 is kind of a floor around due process, but the Education Code actually enumerates it articulates a very clear process, and that it would be, better to follow. If you find that you have a policy that does need changing or updating, for example, a volunteer hours policy, it's important not only, to community, because if the understanding is that has been a requirement, you want to let folks know that that is not the case. Going back just with the authorizers, considering the composition of your school and really grappling, are there any potential barriers, and reflecting on whether that may be resulting in a composition of your school that is not reflecting the greater community. To the next slide.
This is Angela. I'll take this one. So it's really important for students and families to just become familiar with AB 60, become familiar with the Charter School Act. If you apply to a charter school and you think that that charter school is engaging in something that seems discriminatory or exclusionary, or you have an understanding that the composition of the school isn't reflective of the community, you have concerns like that, you should file a complaint with the principal, then with the charter school board, and then with the authorizer. If you or someone in your community is facing suspension or expulsion, or if the school administrators just ask you to leave the school, or say that you're disenrolled for some reason, you should ask for a hearing to challenge it. You should also ask for those due process protections that we highlighted earlier, and really make it clear to the school that those are the things that you are seeking in that situation. Next slide. So for all the folks who are here on the call with us, what is one thing that you're going to take back to your communities, given the role that you play in relation to charter schools? What's one thing that you're going to do to help make sure that there's not exclusion of students, and that their schools are providing due process? And if you could just type that in the chat box. Any ideas that anyone has, you can just type that in the chat box. Great. Okay. Wow, someone's saying they're going to ask all their charter schools to report compliance on the bill. That's really great. Ensure that their staff understands all the laws. Continue to provide professional development, support opportunities. Wonderful. This is all really awesome stuff. Next slide. So we want to thank you all so much for your time. We're actually at time, right at 4:30. If you have some other questions that you just want to drop in the Dropbox, we'll be happy to try to follow up with folks. And we will make sure that the materials are available. Some folks were requesting the recording. The recording will be available on this landing page. And we are so grateful to you for your time today, and thank you all for joining us.